Well, good afternoon, everybody. How was lunch? Good. Well, we'll try to keep this interesting for you for the next 7 hours so that you don't overload on carbs. Another one of my bad jokes. Let's review where we are in this process. We spent last night establishing a basic pro-life case. And here's what that argument looks like. We argue scientifically that from the very beginning, from the earliest stages of development, the unborn are distinct, living, and whole human beings. They are not part of another human organism like these cells that I'm plucking off the back of my hand. Rather, from the very beginning, the unborn are themselves whole living entities. That's what the science of embryology teaches us. We argued then philosophically that there was no essential difference between the embryo you once were and the adult you are tonight that would justify killing you at that earlier stage of development. Differences of size, level of development, environment, and degree of dependency are not good reasons for saying you had no right to life then, but you do now. That's our basic case. And that case can be communicated in 5 minutes or less, and in fact, you'll be able to do it in a much shorter time period than even that as you become more adept at this. We also talked about the 4 tasks of the pro-life apologist, and we've already knocked out 1 and 2. The first task was to clarify the debate, show that it comes down to one issue: what is the unborn? It's not about choice, it's not about privacy, it's not about trusting women to make their own personal decisions. What tactic did we teach you to help you bring it down to the one question? Trot out the toddler. And that's a tactic you'll be able to use with people. In fact, you're supposed to train yourselves, as we mentioned last night, that anytime you hear an argument for abortion rights, what's the first thing you're thinking? Would this work as a good argument for killing a toddler? And if not, what is the person assuming about the unborn? That they're not human. And you'll be able to point that out to them in the course of your subsequent discussion. The second task, we said, is that pro-life apologists have to establish a foundation for this debate. The foundation we established last night was the substance view of human persons. That human beings have value in virtue of the kind of thing they are. They do not change from one kind of being to another in the course of their development. Rather, the kind of thing they are remains the same through time and change. And unlike a property thing like my car that is put together part by part, human embryos do not get constructed from the outside. Rather, they develop themselves from within according to their inner natures. Then we also looked at objections to that view, and we showed how the arguments of Marianne Warren involving self-awareness, Steven Pinker, who says that human dignity is not even necessary, that autonomy and consent can provide the foundation that we need. And then we looked at Peter Singer and what were some problems with his argument. That's where we went last night. We're now ready for the third step in this process, but before we get to that, I want to do a little exercise with you, and I'm going to ask you to write down some things that were spoken by an opponent of mine in a recent debate. And then I'm going to put you in your groups to go over them. And once we do that, we'll be ready for our third step in this, which is to answer objections persuasively. And then finally, we'll talk about what it means to equip and engage, and how we equip people by teaching them the pro-life apologetics that we've been looking at here. So that's where we're going for the rest of our time together before we quit at 4 o'clock this afternoon. So here's what I'd like you to do. Get ready to write, if you would. I want to take you back to the University of North Carolina, Chapel Hill, last October, almost a year ago now, where I was debating my friend Nadine Strawson, who I referenced earlier. And I want to give you something she said at the end of her opening speech that was her attempt to ground the proper way we ought to approach the abortion issue. So get ready. I'm going to have you write these statements down. Statement number 1. She said the following: laws restricting abortion unjustly restrict the freedom of women. Laws restricting abortion unjustly restrict the freedom of women and impose the religious beliefs of some on others who disagree. That's statement number one. Laws restricting abortion unjustly restrict freedom and impose the religious beliefs of some on others who disagree. Statement number two that she said, our individual principles of morality cannot control judicial decisions. Our individual principles of morality cannot control judicial decisions. Our obligation is to liberty. So that second statement, or actually it ends up being two, the second point, our individual principles of morality cannot control our judicial decisions. Our obligation is to liberty. Statement three, we must respect freedom of conscience that allows women a right to choose. We must respect freedom of conscience that allows women a right to choose. Statement four. The state should not enter the private realm of family life. The state should not enter the private realm of family life. Government must remain neutral. The state should not enter the private realm of family life. Government must remain neutral. And then finally, she quoted the Supreme Court in the infamous mystery passage found in the Casey decision of 1992, and here is the quote she ended her speech with. It's from the Supreme Court's Casey decision of 1992. Here it is, and I'll give it to you word for word. You can put this in quotation marks. At the heart of liberty is the right to define one's own concept of existence, comma. At the heart of liberty is the right to define one's own concept of existence, comma, of meaning, comma, of the universe, comma, and of the mystery of human life, end quote. At the heart of liberty is the right to define one's own concept of existence, comma, of meaning, comma, of the universe, comma, and of the mystery of human life, end quote. Everybody got those statements? Anybody need me to repeat one? The first one? Laws restricting abortion unjustly curtail the freedom of women and impose the religious beliefs of some on others who disagree. All right, here's what I'd like you to do. Buddy up with 2 or 3 people around you, and I want you to tell me what are the flaws in those statements. Based on what we talked about last night, about how the concept of metaphysical neutrality is impossible, and based on other things we said last night, what assumptions is she making in these statements? Go ahead and buddy up, and then I'm going to pull you back together. So, ready? Go ahead and buddy up, grab some people around you, and I'll pull you back together. All right, let's get some feedback on this. Let's get into this. What did you find about her statements? Do they work? If not, why not? What's our fundamental problem going on here?
The unborn is ignored in every one of these.
Does she assume the unborn aren't human? Yeah. Absolutely. Yeah, and what was your clue that that was the case? I agree, it's implicit throughout the whole thing, but there actually, I think, was a statement or two in there that really shows us that's what she's doing.
Well, she says, our obligation is to liberty. I would say, can't the unborn be included in our?
There you go. She uses the word are, but it's a very select group that she has in mind, and it doesn't include the unborn. And by the way, would she argue for a right to liberty if parents wanted the right or liberty to kill their 2-year-old? No, so she's clearly begging the question. Agreed. What else?
I'd say, he's talking about religion, that as if this is a religious issue. They're totally ignoring the fact that it's a life. It's not a religious issue.
So Nadine was casting this as a religious issue, okay? And therefore dismissing the scientific and philosophic case that's been made for the lives of the unborn. Yeah, I think that's going on here, definitely. What else?
She's also saying that her beliefs are fact and my beliefs are myth. She's saying you can't impose your beliefs on me, but I can impose mine on you.
And also excusing herself from that category of having a religious belief. She has religious beliefs.
Exactly.
Even if she's an atheist, she has a set of beliefs she's living by, and she's imposing that morality.
Is her position truly neutral? She appealed to moral neutrality, but what was the clue that her position truly wasn't neutral, though she made an appeal to that? What words gave you the heads up that...
Should, ought, must.
Yeah, should, ought, must. We have an obligation to. Says who?
Yeah.
Is that true morally or just her position, you see? Which I, by the way, pointed out in the debate, in my rebuttal speech. For someone who's saying we should not have a moral view imposed, she's certainly quite adept at imposing a moral view when it comes to her own position. What else?
She's assuming that there are no moral absolutes in the second sentence, where individual principles of morality can't control judicial decisions. Well, they should if they're proven true moral absolutes.
Yes, Nadine assumes that moral questions are really preferences that we should no more impose on someone than we would a taste in ice cream, for example. Yeah. But of course, as was just pointed out, what does she then turn right around and do? Impose a view. We should have this obligation to liberty. Yes, exactly right. Was her position legally neutral? And what was your heads up on that? How did you get a hint that although she appealed to state neutrality, it really wasn't?
Well, the state is imposing upon me to pay for what's happening in those abortions.
Yes, it is. In other words, you may be opposed to it, but you're going to pay for it anyway.
That's right.
Correct. That's certainly true.
She says that the state should not enter the private realm of family life and that they should remain neutral, but at the same time, that would be their stance, being neutral. It's not no stance. They have to have neutrality or one or the other.
And you can tell it's what neutrality is.
Right.
Right, the idea of neutrality is to rob somebody else of the rights, namely the unborn.
Can the state be neutral? And how do we know that? Precisely. The state either recognizes the unborn as human and thus protects them by law, or it does not and allows killing them. State neutrality is an impossibility in this question. The same is true with gay marriage, right? The state's either going to allow it or it's not. There's no middle ground here. The same is going on here with the pro-life view. The state will either recognize the rights of the unborn or it's going to allow killing them. If it allows killing the unborn, what is the state's implicit position toward the value on the unborn? That they're not worth protecting, because the state would not argue that way if we were talking about 2-year-olds. So it's taking the position that embryos and fetuses do not have the same value and rights as 2-year-olds. That is a metaphysical position, that is not neutral, and that is the state taking sides. Now, I want to be clear, I'm not against the state taking sides on moral questions. It has to. What I am against are these phony appeals to neutrality that aren't neutral. And they're used to kind of short-circuit the debate when in reality the state is taking a position. All right, what else did you notice in Nadine's statements? Yes?
The second one, she talks about morality not influencing judicial decisions, but that happens every day all over
Yes.
the country.
Yeah.
Judges have access to the same legal documents, but they understand them differently.
Judges impose moral views all the time. And by the way, not just judges, state legislatures, Congress. Hadley Arcus makes a good point. If the state doesn't legislate morality, how do we justify taking away people's freedoms? What are we taking away their freedom based on? Our preferences as lawmakers? The only legitimate foundation for legislation is morality. Because otherwise you're saying, I'm going to strip you of your freedom just because I have a preference that I don't like about you. What we need is some kind of foundation for that, and morality is that foundation. Other comments on Nadine's statement? Yes?
Along with that, statement 4, she says the state should not enter the private realm of family life, but the state does this all the time. If, there's a domestic violence incident, the police show up. If children are being abused or neglected, Child Protective Services gets involved. Inheritance rights are all legally adjudicated. So the state's already involved in family life. So.
States involved all the time. In fact, in our session this morning with Dr. Ray, he was talking about social workers getting involved in end-of-life issues, and they're certainly involved in child care issues. So yes, the state is involved in private family life all the time. Let's take what I think is the most problematic thing that Nadine said, and it wasn't her own words. She quoted the Supreme Court in the infamous Casey decision. The mystery passage in Casey is, without question, the most famous sentence, I would say, in the last 20 years or the last 18 years of American law. Here's what it says, and she quoted it. At the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life. Here's my question. If that is true, are any of our rights secure? They're not. Why?
My next door neighbor can define me out of existence.
Your next door neighbor can define you out of existence. By the way, I'm a judge. Why can't I just make up women to be creatures who don't have a right to an abortion, because that fits my view of the universe and the mystery of human life? What's Nadine going to say at that point? If it's up to us individually to decide that question based on our own individual perceptions of the universe, I don't see how she could say it would be wrong for a future court to decide that women do not have a right to an abortion and they're not creatures that we need to recognize as having that right to an abortion, or any other right for that matter. It really provides a very insecure ground for human rights. And this is a point that Hadley Arcus brings out brilliantly in his book, Natural Rights and the Right to Choose, which I mentioned in our last session. His point is this: secular liberals have talked themselves out of the very foundation upon which their rights are built. By reducing human nature to something that is subjective rather than fixed, they have eroded the foundation of their own rights, and including their own alleged foundation for a right to an abortion. Because think of it this way. If you ask your typical abortion rights advocate, where does the right to an abortion come from? What's he going to tell you? From the state. Fair enough. The same state that grants a right to an abortion can do what? Take it away, exactly. Now, at that point, typically your critic of the pro-life view is going to say, well, the woman has a fundamental right to an abortion. What's your next question? Where did that come from? Exactly. Now they're getting very dangerously close to talking about you-know-who, right? Because if rights do not come from the state, what's the only option open to us? A transcendent source. But if we have transcendent rights, don't we kind of have to have a transcendent rights giver? Yeah. So their very attempt to throw metaphysics out of this ends up rebounding against them big time. And Hadley Arcus makes this point brilliantly in his book, Natural Rights and the Right to Choose. So, just to wrap up what we talked about yesterday, there is no way for metaphysical neutrality on this issue. The state can't be neutral. It either recognizes the unborn as having a right to life and thus protects them, or it doesn't recognize them having value and a right to life and thus permits killing them. Moral neutrality is not possible. Everybody takes a position here. Everybody's advancing a moral point of view, as indicated by Nadine's words, should and ought and obligation, and so on and so forth. Everyone's taking a position. Everybody's doing metaphysics. There is, however, a political philosopher who stepped into this fray about 25 years ago by the name of John Rawls, actually before that even. But his book, Political Liberalism, came out, and in that book, Rawls argues that society ought to confer a great deal of liberty on controversial issues that there's no consensus on. And Rawls's basic argument was that when it comes to an issue, let's say like abortion, the government should not legislate against it when there's a consensus that is non-existent. And as a result of that, when the government takes a position on a controversial issue, it's unjustly stripping people of liberty. That's in essence what John Rawls was arguing. And I think you could see that Nadine was borrowing from Rawlsian thinking here when she was making her appeal to liberty. That comes directly from John Rawls. Now, the thing that's interesting about John Rawls, he wants to make it very clear that the state should not take a metaphysical position with a comprehensive doctrine involved on controversial issues. The state should stay out of controversial issues by not imposing a comprehensive doctrine of reality, and instead what we should have is state neutrality. Is that possible? No. Now, what's the first thing you notice about Rawls? What kind of statement is this? The state must remain neutral. It should not legislate on controversial issues. It should not get involved in comprehensive doctrines. What kind of statement is that?
It's a comprehensive statement about what the state should be.
It's a comprehensive doctrine about how the state ought to function, which means we're doing what?
Morality.
Metaphysics. We're right back in it. So even at the academic level, you can't avoid this. There is no neutrality. And the thing is, you will find again and again when you get out there in the public square, people try to short-circuit the debate by saying, we have to have neutrality. It's not possible. Everybody takes a position here. In fact, even Roe versus Wade, the Supreme Court decision that legalized abortion in 1973, is anything but neutral. Here's a little hint. When someone says to you the government needs to stay out of the abortion issue, the first question out of your mouth ought to be, including the federal courts? Yeah. Because here's what happened. The Supreme Court in 1973 did not get the federal government out of the abortion issue, though that's what we've been told. What the Supreme Court did is tell the legislative branch and the executive branch, shut up, you have no say on this issue. We, 9 men on the federal court, are going to decide what national policy will be on abortion. The people's voice through their elected officials is silenced, and a different branch of the federal government, the courts, 9 justices, unelected, accountable to no one, those guys determine the policy. Is the federal government still involved in abortion? Yes, it is. Here's the problem. It's now involved in such a way that the people have no say over it. So when people tell you, well, I think that Roe v. Wade was great, it got the government out of the issue. It did? No, it didn't. The courts just co-opted the issue from the legislative and executive branches and asserted itself as the sole authority. So what did Roe do? First thing Roe v. Wade did is the following. It took the laws of all 50 states and threw them out. Even states that had liberal abortion laws, it threw those out. It cleaned the foundation, if you will, of any existing legislative law on abortion in all 50 states. The court then imposed its own standard of abortion policy, and here's how it looks. In the first 3 months of pregnancy, the state may not interfere in the woman's decision to abort for any reason. In the second trimester, the second 3 months, the state may only regulate where the abortion takes place for the sake of protecting the safety of the mother, but not the unborn. So for the first 6 months, the state has no compelling interest in the unborn whatsoever. In the third trimester, the court said that the state now has a possible compelling interest in the fetus, and it may, doesn't have to, but it may pass laws to protect potential human life, but there is a huge caveat. However, those laws that are passed on behalf of the fetus must not interfere with a woman's, quote, health. Now comes the really interesting thing. What do we mean by health? At the same time Roe v. Wade was passed down, a companion case known as Doe versus Bolton was also decided. Roe v. Wade said that laws against abortion must not interfere with a woman's health. Doe v. Bolton then defines what health is. And here's how the health decision or health consideration looks. Health is defined so broadly you could drive a Mack truck through it. Because the Supreme Court said the health decision needs to be made in light of all factors, psychological, family, socioeconomic, all things related to, and here comes the weasel phrase, all things related to the woman's well-being. I don't know about you, but that just about covers anything you might need as a reason to secure a late-term abortion. And this is why the U.S. Senate Subcommittee in 1983 concluded there was no substantial barriers to a third trimester abortion at all. In fact, for all practical purposes, it's legal up until the moment of birth. Because that health exception is so wide and so broad, it literally is useless. Now, is that a neutral position of the court? No, not at all. But not only that, it's interesting how Justice Blackmun arrived at his decision, because his reasoning was unbelievably faulty. And if you want a good analysis of his faulty reasoning, pick up Frank Beckwith's book, Defending Life. He's got a chapter on the faulty reasoning of Roe versus Wade. And just to give you a couple of highlights, Frank goes into this in much more detail than I'm going to here. Here are the two biggies. The United States in the 1860s began passing laws against abortion. There was a movement that began known as the Physicians' Crusade Against Abortion. Physicians, responding to new scientific evidence, began to say, wait a minute, quickening is not when life begins. We now can point to a time much earlier than that when we have the presence of human life. New genetic information was becoming available. The science of embryology was beginning to show up. And these doctors said abortion at any stage is the unwarranted destruction of human life. In fact, by 1869, and then shortly thereafter, by 1880, we had virtually every state and territory with laws on the books against abortion. These laws were not written primarily to protect the mother from unsafe surgical procedures. When you go back and read books like James Moore's book, Abortion in America, or you read Marvin Olasky's book, Abortion Rights, you find out that the purpose of these laws were to protect the unborn. Well, Blackmun decided he needed to rewrite history. And what he did is he found an attorney who was willing to present an alternate view of these abortion laws. And what he did, an attorney by the name of Cyril Means argued that the primary intent of these abortion laws in the 1800s was not to protect the unborn, but to protect women from unsafe abortion procedures. And now that abortion was largely safe, there was no reason for these laws, and the court could step in and find them unconstitutional. The problem was that history is completely bogus, and even historians who support abortion rights have made that point. This history that Blackmun relied on was not reliable history in the least. Blackmun also relied on the 14th Amendment to throw out laws against abortion. And he appealed to the 14th Amendment as if somehow that amendment made it possible for the state, or rather for the court, to throw out any restrictions on abortion. But let me ask a question. The 14th Amendment was enacted at the same time the states were passing laws against abortion in the 1880s. Do you think just possibly that if the framers of the 14th Amendment intended for it to be a liberty for abortion, they would have said something about all of the states that were currently passing laws at the time against abortion? I think so. So on every level, what you have is Blackmun's history falling apart, not being reliable at all, and certainly not being neutral in any sense of the word. And the other thing the court did is it relied on a theory of human rights that was anything but neutral. Let me give you just the dividing line that we see in our culture today on where human rights, basic human rights, come from. There are two views. The traditional view, as John T. Noonan points out, Judge Noonan, is that your rights as a human being are not given by government. They're something you have by nature. You have them simply because you're human. These are what we call natural rights. They flow from your human nature, and government's job is not to grant these rights. Government's job is to protect them. There's a foundational document where this idea comes from. Which document is it? Not the Constitution. Not the Bill of Rights. Declaration of Independence. If you want to know what is the most important document in United States history, I say it's the Declaration of Independence. And what kind of rights did the framers appeal to in that document? Natural rights. Human beings have certain rights in virtue of what they are. Those rights come from their creator. Government's job is to protect and affirm those rights, not create them. That's the traditional view of American jurisprudence. However, in the 19th century, there emerged a competing view by an Austrian jurist by the name of Hans Kelsen. Kelsen said, natural rights are not where this is. Rather, the state is the stopping point for rights. Human beings don't exist as a natural reality, said Kelsen. Rather, get this, they are a construct of juristic thinking. In other words, you don't have rights because you're human. You have rights because legal scholars, judges, lawmakers say you have rights. Everybody see the difference in the two views? The traditional view says your rights come in virtue of your humanity. You have natural rights in virtue of what you are. Kelsen comes along and says, hey, no, human beings are a construct of juristic thinking. Two very radically different views of the sources of basic human rights. There was actually a Supreme Court case, a New York State Supreme Court case that took place just a few years prior to Roe versus Wade, where Kelsen's thinking was put on display in clear view of all. It's a case that was known as Brin versus New York City Health and Hospital, and here's what happened. The court made a decision that abortion was okay. That's nothing remarkable in itself. But that state court then proceeded to justify its opinion, and here's what Judge Charles Breedel said. He said, while it's unquestionably true that the unborn are alive and human, the natural order does not correspond to the legal order. He just defined the unborn out of existence with judicial fiat. Guess what happened in Roe versus Wade? The same exact line of thinking. In other words, humans don't have rights in virtue of what they are. They only have rights because of what the court declares. And John Noonan has a great line. He says, your basic rights flow out of your humanity. But if it's up to 9 men to judge you out of existence, none of our rights are secure. And this is what the problem is with political liberalism. It appeals to rights, but what's the foundation for those rights? What they mean is rights that the court declares, not rights that you have in virtue of your humanity. So this is where we've ended up. And by the way, it's interesting to me, just a little irony here. The Supreme Court actually, as Frank Beckwith points out, undermined its own right to abortion in Roe v. Wade, and here's how. Frank says, Judge Blackmun, the judge who penned Roe v. Wade, Judge Blackmun said that the right to abortion was contingent upon the status of the fetus. All right? Pause right there. What did the court say then about the status of the fetus? We don't know if it's a human life. We don't know. Philosophy, theology, science can't agree, therefore the court is in no position to determine when life begins. Uh-oh. If the right to abortion is contingent upon the status of the fetus, in other words, is it or is it not human, and the court doesn't know if the unborn are human, what else doesn't it know? If a right to an abortion exists, right? Because if the right to abortion is contingent upon the status of the fetus, and the court doesn't know what the status of the fetus is, it also doesn't know if ever there is a right to an abortion. So the court undermined its own position in Roe v. Wade. I even asked Nadine about this when we were sharing a limo going up to the Cleveland airport after we had debated at Malone College. I said, Nadine, do you find it odd how Blackmun reasoned in Roe v. Wade? And I gave her that little irony I just gave you. And she just said, interesting, I'd never thought of it that way. So I can't wait to bring that up in our next debate. But all right, that's where we are with neutrality. And that's why we can't have neutrality. It's not possible. It's not going to work. Questions on that before we move to bodily rights?
Roe versus Wade, did they ever argue about the nature or whether the unborn were?
The question is, in Roe v. Wade, did they argue about whether or not the unborn were human? No, they did not. That's one of the big problems. Because the court said, we don't know if the unborn are human because philosophy, theology, and all these other disciplines, the court said, don't agree. As if somehow the absence of consensus means nobody's right. But the court really did claim to know when life begins, didn't it? Because it said abortion was legal through all 9 months of pregnancy, meaning what? Life begins at birth, in their views. So they really were taking a position, though they pretended they weren't. They really were taking a position.
Biola University offers a variety of biblically centered degree programs, ranging from business to ministry to the arts and sciences. Visit biola.edu to find out how Biola could make a difference in your life.